Welcome everyone to the first of a series of 5 webinars that we've got this week going on, where I'm going to be talking with business owners throughout New Zealand who work in and around privacy matters. Privacy Week was launched this morning. There's a number of initiatives underway, and I really do appreciate you all joining us for this discussion. Today, I'm very pleased to have with me Mark Anderson, who is a expert in the field that I've known for probably coming up 10 years now. Mark and I have worked on a number of incident response jobs involving privacy breaches, and then obviously tried to help clients also move into the improvement area around cyber governance, privacy management, and so on and so forth. So thank you, Mark, and welcome. How about you give yourself an introduction?
Thank you, Campbell. It's a real pleasure to talk with you today and share some insights into what it means to be a business owner here on Privacy Week in New Zealand. There's so many materials, seminars, posts this week, but it's nice to be able to bring it back down to a personal level as how I manage a business and those I work with who manage businesses as well. Thank you for the question about the role I play. I'm a cyber lawyer and a privacy lawyer, and I've worked in this role for many, many years. I started not long after New Zealand got its own Privacy Act back in 1993, so I've been in the game for a while. Privacy back then was seen as a largely governmental problem and a governmental responsibility for organising rules and a framework for privacy. But it was seen as lawyers and academics that were engaging with it, and it's taken a long time for organisations, for businesses to really, come to play with how they work within that framework. And many organisations, frankly, just kind of missed the point about what the Privacy Act was for many, many years. But back in the 90s, data was lost on buses, in briefcases. Thieves were concerned with stealing from bank vaults and taking hard currency, not data. Computers, they might have been on desks. I had one, but everything we had was printed. It was sent by post, lost by post. And sort of by the noughties, that all changed dramatically. The world is a different place. We all started trading online. We're all transacting online. The data that we deal with is just massive now. So those who are smart realised that currency was data, it was information, and it was easier to exchange and pass that information backwards and forwards. But criminals realised there was currency in stealing the data. So I, in my role, changed from working as a lawyer advising clients on risk generally to specialise in risk involving the privacy of information. And helping clients when the proverbial hit the fan and people had their data stolen or access was denied. And so I've worked for many, many years with the New Zealand Police, people like Campbell and forensic organisations and companies in protecting their data, getting it back, and making sure that they've got good, robust processes in place for dealing with things. I built a team of lawyers in my business to assist, to assess what data is vulnerable, how best to protect it, and should the worst happen, how we get it back, to play with the stakeholders that you have within your organisation, organise plans, incident response plans, marshal external vendors if that's required, communications, media, IT capacity, forensic capacity like IRS, call centre staff, regulators, the OPC, Privacy Commissioner, if we need to as well. And so I've worked with those clients for many, many years now. We have 40 or 50 cyber incidents a year that we deal with within my business. And that's where I'm helping clients who have had their data stolen or impacted, had their systems interfered with. And those are clients as large, they might be an institutional bank, a lender, financial companies, infrastructure utility providers like ports, electricity providers, but also mum and dad businesses who are quite, ignorant of what's at stake, what's at play, what their obligations are. So even when a company's got best policies and procedures, there's always learnings to be had. And it's just a real privilege that I can now work with businesses both to overcome their privacy problems and their concerns when things do happen, when there's an incident. But equally, it's an honour to utilise that information that I've gained over all those years of experience to help businesses minimise the chances of there being a problem in the first place. So that's a little bit about my business and what I do and how I work.
Thanks for that, Mark. So tell me also a little bit, obviously you talked there about building up a practice in the law firm. You set up your chambers last year. For the people on the call or anyone watching this in future, say someone in an organisation who's a privacy officer, what is the interplay? How does it work together between internal privacy and legal responding to a breach, a law firm that may get engaged to assist, and your role as a barrister?
Yeah, so that can vary greatly depending on the incident. But the first thing we do, and we work to frameworks which have been created by international best practice standards and overseas government protocols. But the first thing we do is we assess a breach and what's required for the response. And we can work by as intimately getting into an organisation and rolling our sleeves up and actually assisting the business in making decisions when that business is in the most vulnerable place where it is unable to do so itself. So there may be an organisation or an institution, for example, who has no internal privacy frameworks, has no controls, has no people actively responsible. And so we can get in there and we can advise clients and walk them through during that time of need what needs to be done. So, for example, under the Privacy Act, we have mandatory notification provisions and regimes and strict timeframes for doing so to notify the Privacy Commissioner when there's been lost information of a personal and sensitive nature. So we can get in there, we can notify and assist the client by actually doing the notification to the Privacy Commissioner, walking them through that, walking through a roadmap and how we're going to deal with that and address that and make sure that we minimise the impact. If we switch to maybe a larger organisation that's already got its own team, it's got a decent incident response plan for when there is a loss of data or potential vulnerabilities that are being impacted. We can helicopter out and we can often offer assistance in terms of a critical review, audit, assessing whether things could be done differently, improvements for the future. So we can really tailor that need to the organisation. Often we'll sit down with an organisation before there's been a loss and we'll map out a plan of how that's going to work, a gameplay, and how we can add value and what we can do to add that value when there is an incident.
Great, thank you for that, Mark. So it's Privacy Week. We've kicked off. We have people listening to us. What would be your key recommendation to those who want to do something slightly better at the end of Privacy Week?
I think Privacy Week is a really good chance for us to reflect on our own businesses and how they work and what we could do to improve them and the frameworks that we have in play. For me, personally, it's a really good framework for even me to just go back and identify what can be done better. Protecting information is all about creating trust and confidence in our businesses, and privacy underpins that trust in our customers and the delivery of the product we produce or the services we deliver. And we're lucky to live in a society which has, values that. So it's a great chance for us to refocus our business minds on the obligations that we have and the data that we give to people that we serve. So for some people, it'll be going back to the basics, and it'll actually be refreshing obligations under the Privacy Act itself. And we have a relatively new set of obligations under our privacy provisions, which have carried on throughout my whole career. But the Privacy Act 2020 has some new obligations, some additional obligations, for example, around when we lose information, how we report, timeframes for doing that. So for some people, it's going to be to go back and actually go, okay, well, actually, are we compliant with those new obligations under the Privacy Act? I think for some businesses, it's a chance to reprioritize their security. And depending on what information you've got, whether you possess it digitally or physically, ensuring that you've got adequate security systems in place. So, for example, are you actually implementing two-factor identification in play? Or have you, for example, got your outsourcing contractors adhering to best practice standards on their security measures? And what should that actually entail, or what that should be in reality? And certainly, when we're dealing with outsourced third parties, we can't just delegate necessarily to that under the Privacy Act. The information that we hold is our responsibility, regardless of whether it's in our organisation or we've delegated it to a cloud service provider or another third party. And increasingly, we're seeing external threats from on third-party providers, for example, IT vendors, as you well know, working in IRS. So for some, it's going to be basics as that. I think it's going to be a good chance for them to actually target and resource new initiatives. It may be, for example, undertaking formal policy reviews or procedures, setting new standards at management or board level, because I think these conversations need to be had right through the matrix of your organisation. It's not the privacy officer's responsibility to deal with things, or an individual who's been delegated a responsibility to get processes in play or training in play. It goes right through. So this is a good chance for us to actually remind people of that as well. It's a good chance to, if we need to, we haven't done it for a while, undertake privacy audits or reallocate training budgets, for example. I think it's also a good reminder that this Privacy Week is not only a New Zealand thing, it is a global Privacy Week, and there are various forms that have happened over the last month or so. But we have obligations not only here in our organisations in New Zealand, we have obligations around the world, and there are different rules that come to play when dealing with information depending on where you are in New Zealand, where you are in the world, be it New Zealand, or if you've got clients and data, or you're managing clients and data outside New Zealand. So it's a good chance for us to remind ourselves and actually think about the obligations of working offshore, holding information offshore. For example, are we deleting data in accordance with standards and applications in the UK and Europe under the GDPR? There, they have the right to be forgotten. Here, we don't. So there's no positive obligation for us to be, getting rid of data necessarily. And I think it's a chance for us finally to be proactive about how we deal with information and privacy, rather than being reactive, just to refocus the minds of our businesses, including mine.
I'm going to pick up on the proactive point you've just made there in a second, but it's fair to say a lot of people out there see this as a very difficult and challenging topic. I often get asked, how do I stay private? And one of the famous quotes from one of the researchers is, you'd have to be living under a rock. Now, unless you've been living under a rock over the last sort of 6 months, 12 months in New Zealand, the attendees today and other people watching this in future will no doubt have heard about a lot of cyber breaches in New Zealand that are impacting individuals and organisations. But if we think perhaps back 5 years to today, and we think about critical assets, people's crown jewels, in your experience, what would be a couple of suggestions for how organisations should ensure their crown jewels remain as secure as possible, not just from a technology point of view, also from a privacy governance point of view as well?
Yeah, I think that's that last sentence is actually probably the most important, that your crown jewels are not only protected by privacy, and certainly even in the last 5 years, when we see data breaches and we see businesses impacted, it's often not because of some security measure that's been in play or not been in play. It's because of how people have been managing it. So the best advice I can say is that even for the most prepared and most well-resourced, those who have comprehensive privacy teams within the organisations, even those who have the best security in-house or external, is always to think that your data could be impacted by some means, some form, or some fashion, and be prepared to deal with that in the event that that happens. Because the moment that you turn your mind to, oh, we have good systems in play, that's when complacency can come into the fore. And it is always human error that can ensure that your data is impacted. So it may be that a security control hasn't been ticked in the box through malware protection. It may be that somebody hasn't adhered to a policy or a procedure that's in play for ensuring that you don't use certain software on your systems. There's always going to be some risk in the fore. So implementing a mindset of you will suffer a loss will always lead you into a better place and plan. So having a good response plan in play is really important. Implementing that response plan is really important. Making sure that critical people within your organisation know who to turn to when something does go wrong is critically important. But if you have the resource or the power to do so, testing that plan as well in some form or fashion. So that may mean sitting down once a year and having an hour-long chat to someone like Campbell at IRS or myself or both. Or it may mean actually going and implementing a test throughout the whole organisation and actually working through what is this going to mean, who's going to do what, when is it going to be appropriate to address the board. You may have a listed company, you may have to notify stock exchange, you may have to notify government, you may have contractual obligations. So understanding what's actually required at play when things go wrong is really, really important. If you can't do that internally, then utilising external resource to do that, or at least to audit and think about how it may be done differently.
I wrote about in the bulletin this month over in Australia, the government have required all banks to partake in a cyber simulation because, as the minister says over there, the banks are just too critical to fail. So they want to be stress tested, they want to be practiced, drilled, and ready that when it happens, that will minimise the impact. I just wanted to put a little bit of an add-on question there to my previous one around supply chain. So certainly over the last year, I have seen more of the customers that were responded to the cause of the breach has been their supply chain. Now, of course, if it's your data and you're hosting it with someone else, it is still your responsibility. But even just in the last few weeks, we continue to see high-profile breaches in New Zealand and Australia where the organisation is making media statements that it was their third party that was breached. Any comments on that, Mark?
Yeah, pushing the responsibility may have some impact in your mind, but it often has very limited impact to the individual affected. So if you take the lateral breach, for example, that's impacted 20% of the New Zealand population, I don't care that my data's been at the fault of the IT company offshore. All I care is that Lateral had that data and Lateral's lost that data. And what does it mean to me? And I think, when I give advice to clients when these sort of things happen, it's bringing them back to how they actually can convey that message properly and effectively to their clients that, as I said at the outset, it's a privilege to be able to manage that data. Everyone who has that information is doing so because they believe they're delivering a good service to their clients. And the client is the most important thing to that business. It's what keeps that business ticking. So refocusing the mind on that is important. Owning it and owning responsibility. At the end of the day, it's going to be a matter for me as a lawyer to actually fight to argue who's responsible. And I think we do become a little complacent too, because we have third-party providers who are giving us expert advice and expert services, cloud service provision or whatever it might be. Often the liability between the parties is not clear-cut, and so at the end of the day, the Act, the Privacy Act itself, conveys the obligation on your organisation, regardless of whether or not you've put it out to a third party.
Okay, thank you. Just looking at the time, what we want to do is allow a little bit of time for questions at the end, but I thought if I combine a couple of questions to round it out, Mark. One would be, as everyone is challenged by resources, recruiting in people into their organisations right now. Budget is another thing. And we all know when we talk to our clients that there's some issue that's causing them, or to prevent them from sort of moving ahead with their privacy game. Looking at the most common challenges organisations have, and looking at what you do in your day-to-day job, what do you have to the audience here today to say about how you can help?
So I think tailoring need to an organisation and their capacity and resources is a really important thing. And every organisation can pick 2 or 3 things within their business to tweak and focus on, and tailor that to their resourcing and ability to do so. So it may be that you're a small organisation and you don't have a lot of ability to onboard and spend money around that. Getting some advice that you can actually use to actually effectively go, okay, well, there's a training system that's available, which can be tapped into for detecting phishing and get staff prepared. And that training system is a cost-effective measure, is really helpful. But it may be that you've got a large organisation, and implementing in-house teams to do that is going to be important. So getting that advice from the right people is critical. And that's something that we really work to assist clients with. Do you need a full day training session, or do you need 20 minutes here, 20 minutes there, and at a much lesser cost? So we work with clients to actually tailor and address what's required as needed.
Perfect. Well, thank you for that. And I think that pretty much rounds out the Q&A that you and I were going to have. I have just popped up in the chat there. If anyone has any questions, now's the time to put them to Mark or myself. So we'll give you a few seconds to put some questions in the chat. I'm sure someone has some questions. And if not, I'm going to throw another question at you very shortly.
Why not?
Okay, so just while people are thinking about throwing those questions in there, one of the other things that I sort of wrote about in the bulletin that we've just put out is around having a holistic privacy view, combining them with the cyber requirements of an organisation. What I often see is a bit of a disconnect between management, legal/privacy, and IT, where people still don't quite realise that it is the wider business problem. What would you say to an organisation who is sort of still saying that's for IT to sort out?
Yeah, that's a real common issue in many businesses. What I say is that information is the core of all businesses these days, and the protection of the privacy of that information is critical. Everything we do in business involves data. Data needs to be not only secure, but it needs to be managed properly. So as I said earlier, it's really a board issue right from the top. CEO needs to have this information sitting at boardroom level. They need to bring that to the table as an agenda item regularly, because if they don't, they have liability themselves. And so integrating the IT and the privacy decision making, the management and systems to ensure that information is protected goes all the way to the top. And in fact, when we're looking at the lateral breach that we've just had impacting on 20% of New Zealand's population, there are lawyers already.
I think it is.
There's already business lawyers marshalling to bring class actions, and those class actions will be aiming at those decision makers at the top. So, yeah.
Indeed. Okay, well, I don't have any other further questions I was going to pose at you, Mark. It seems everyone's being very kind on us in this first up one of the week. If I can briefly take the opportunity before I thank you and we close out, to just mention, we've looked at a range of speakers this week. So tomorrow we have an employment lawyer coming to talk about the Protected Disclosures Act and obviously the critical importance of keeping that information private if someone is to make a protected disclosure or a whistleblowing disclosure indeed. On Wednesday, we're going to be talking to a business owner who collects data like financial data and hosts it in a system to do fraud analytics. So privacy is absolutely key in their business. On Thursday, we'll be talking about to the owner of a global cybersecurity business who does governance, penetration testing, and so on and so forth. And then to round out the week on Friday, we're going to be talking to the founding partner of a reputation management, crisis management firm about what the things that you need to do to prepare should you find yourself in the spotlight and how you get through your crisis. Because my closing comment would be, for all of the incidents I've been involved in, it's those, no matter how prepared they are, that, you know, take the bull by the horns, do everything right, get out there, control the messaging. That will probably come through it okay. Certainly you'll probably be wounded from it, but it's those who sort of just hope that they'll be able to get through it without applying all the basic foundations in place that might get themselves in a bit of trouble. So Mark, closing comments before we round out?
Yeah, I think just to add from that, those who have the right players in play certainly get through these incidents the best. We do the most to make sure that that trouble is minimised. And we live in a society where, you know, people have been quite forgiving about these sort of incidents. And we live in a society in New Zealand where the implications are not as high as they may be in terms of penalties and fines offshore. That is not going to be the situation forever. So we can't be complacent about that. And we need to ensure that we're on top of our game. So thank you for everyone listening to some of our insights today, and enjoy the rest of Privacy Week.
Indeed. Well, thank you, Mark, for your time. Really appreciate your investment and your time and sharing your expertise with us today. So appreciate it. And we'll thank you, everyone, for attending. Look forward to you attending future sessions this week. Have a great day. See you later.